Warm welcome, warm welcome and good evening to one and all gathered here. So, on behalf of Tamil Nadu chapter, Indian Psychiatric Society, it's a pleasure and privilege to welcome all of you for the Child Psychiatry webinar series. So, as all of you know, some of you have joined today new. So, we have been doing this Child Psychiatry webinar series for the past 6 months. We started off with topics on normal development, adolescent development, and then we moved to neurodevelopmental disorders. And last month, we had a very interesting topic on COPME, children of parents with mental illness. And again, this session, we are having an interesting topic on child sexual abuse. We have a very young, dynamic child psychiatrist on board with us. It's my hearty welcome to Dr. Vel Prashanth Venkatesan. So, introducing Dr. Vel. Dr. Vel did his MD Psychiatry from SIP branch, and then with great passion towards child psychiatry, he did his DM Child and Adolescent Psychiatry from PGI Chandigarh. He's currently working as an assistant professor in the Department of Psychiatry at Sri Manakula Vinayagar Medical College, Pondicherry. And he's also running a private clinic, Mind and Body Clinic at Pondicherry. He has many awards to his credit. Best GR Award at SIP 2018. Ranchi University topper in MD Psychiatry in 2019. Memorial Award for Best Participant at IPS South Zone. Fellow of Dr. Ramakrishna Murthy Foundation, Nuances 2025. So he has authored 3 book chapters and 14 publications in index journals. So warm welcome to you, Dr. Vel. It's a pleasure to have you on board with us. Over to you, Dr. Vel. Vel, can you unmute yourself? Unmute.
Yeah.
Vel, unmute. Yes.
Thank you, ma'am. Thank you for the generous introduction. So I'm just starting off with a note that I'm sure all of us are quite aware of what POCSO is. So what we are going to try and achieve here is to understand from a practical point of view. I know most of us here are either academicians or people who are in private practice, or many who are both as well. So what I'll try to do is to achieve the following objectives here. First, we look into certain legal definitions in POCSO which are necessary for us to understand the documentation part. So we need to understand certain nuances which can later on, come back when there is a requirement of documentation that will go into legal proceedings. And we also need to be aware of how often the disclosure scenarios come through to our, the clinical scenarios that we encounter every day, how often they go under the radar. So we need to know how disclosure itself has a lot of complications. And then we look into our duties as a first level psychosocial intervention provider. And then we go to the tricky part of the section 19, which is the mandatory POCSO reporting clause, and how to go about maneuvering ourselves through this strict liability, which is there. And there are plenty of gray areas. POCSO is not a perfect act. So a lot of times there where we need to again be an advocate and put our best interest for the child in front. And then we also have to have certain competencies that we need to check for the child as this child is going towards court proceedings, and even have a certain preparatory intervention for this child to survive through the court proceedings. And sometimes we also have to survive through being an expert witness. So in summary, in fact, we actually have 4 hats that we need to wear as a psychiatrist here. Firstly, something which all of us are familiar, which is the clinician hat. We have to provide the clinical response for this child who has just come through abuse and trauma. And then we also have to wear the hat of the whistleblower, which is now a mandate by law. And then there are these gray areas where you still have to become the child rights advocate in terms of protecting the rights of the child, where POCSO is not very clear. And finally, you also have to wear the hat of the expert witness, where your clinical data will translate into a potential courtroom evidence in front of the jury. Right? So most of my talk is actually credits to wonderful source materials, as you can see here. One is the Samvad intervention manual. The other one is the Donohue's book on forensic interview in child sexual abuse. And in fact, it is to be noted that the Samvad intervention is running a workshop, which is actually for 2 weeks. So I'm trying my best to put in the pieces together within this 45 minutes lecture, hopefully covering most of the necessary details that you can go back and then reread this content. So it's quite obvious CSA is very highly prevalent, in fact, underreported, and still the statistics show up to 41% in young girls less than 18. And definitely very underlooked is almost 57% in certain institutions with respect to boys only. The NCRB data clearly says The crimes against children, 31% and above or almost under POCSO. And among these, 50% of these cases actually are kids who get lured by cyber predators. So these are things which are on the rise, and we are still waiting for newer data to highlight us what is the current scenario. So let's run through certain legal definitions of POCSO, because these are important terminologies and the levels of offenses that we need to know right upfront as we are entering into the phase of documenting the clinical history itself. So POCSO very clearly states any person, irrespective of the gender, less than the age of 18 will be treated as a child. By that, I mean even a 17-year-old who is just 1 year less than 18 will still be treated as a child under the eyes of POCSO. That's how law works. And the definitions involve certain terms such as domestic relationship and shared household. So any person who is, or a family member who is in a domestic relationship with a child has to be identified. And they are identified using this definition of what is a shared household. A shared household is basically a person charged with the offense lives or has lived any time in the past in the domestic relationship with the child. So these two relationships are interrelated and must be for understanding the offenses per se. So these are the degree of offenses. Right from the top, you have the highest one, which is the penetrative sexual assault. Going down, you have the non-penetrative sexual assault. And going down, you have sexual harassment. And finally, using child for pornographic purposes. I need to get into the details of a little bit of these things. So you need to be aware of which degree of offense is actually visible for you in your clinical history. So a little bit of a trigger warning as we go through. A penetrative sexual assault clearly involves the orifices of a child, a vagina, mouth, urethra, and anus. Any person who tries to enter their private part or penis into it, extend any other part of the body or objects into those orifices, or even manipulates the body part of the own child to penetrate themselves. And all these things, including the mouth into the orifices, are all clearly penetrative sexual assault. And then when we go to the non-penetrative part, it involves the touch without any kind of the artificial penetration, just the touch involving these private parts of vagina, penis, or any of the private parts such as the breast of the child. And all this done with what I've highlighted in sexual intent. Understanding this sexual intent is very crucial, because a lot of your defending parties in court actually try to discredit the sexual intent. So it is important to understand how sexual intent is understood by the victim and the perpetrator here. And then you go down to sexual harassment, where again, as you see, when a person with quote unquote sexual intent makes any lewd remarks to the child, which can be clearly objectifying the child, or even exhibiting or disrobing themselves in front of a child. And here showing pornographic or again similarly disrobed or a naked content to the child again actually amounts to sexual harassment. Or even following or stalking the child, including through electronic and digital means. Or even right now, the fabricated depiction through electronic films of these child, where it involves the child in a sexual act. All this comes under sexual harassment. In fact, the last one with the advent of AI is increasingly becoming a high risk. And then whomsoever uses child in any form of media for purpose of sexual gratification. You see any kind of simulated sexual acts, indecent representation, or enticing a child for even proper pornography. So the offenses here is actually quite in high range. So are the penalties. And now let's look at what is sexual intent per se. One of the only few laws in Indian Criminal Bureau where the victim is not understood to be, innocent until proven guilty is actually POCSO. In POCSO, it's the vice versa. In POCSO, the burden of disproving the sexual intent falls on the accused or the defendant. So the defendant's sexual intent is taken for the fact based on what the child victim is able to provide as the verbatim to the court or the magistrate. And this is very important because a lot of times there is a lot of court cases that are clarified by the sexual intent. One instance is in 2021, a Bombay High Court actually gave a lesser penalty for a person saying that this is not done with any kind of a penetrative act. So it's just touching. And then when it was reappealed in Supreme Court, it was clearly established that it was done, the touching was done with sexual intent. So this does come under the rubric of POCSO. So defining sexual intent actually goes to a long way in legal classification, where they actually define intent into 3 levels, not just sexual intent or any intent for a crime. A general intent is the most obvious one, where it is presumed from the act of commission. You clearly see a child abandoned somewhere with clear-cut injuries or marks of semen. That is clear-cut general intent. The act itself is quite proof enough to show the intent of the person who committed the act. And then you go into zones of specific intent where you need to look at the history in detail. And this is where a lot of our psychiatric history comes into place, especially in the sexual intent of grooming narratives. A lot of your perpetrators actually know the child, right? I'm sure most of you are aware of that. They talk to the child, they spend a lot of time with the child, they lure the child into online chats and everything. But you have to look into the specific intent, which has a pre-planning and a predisposition towards a later on actual sexual harassment or a sexual assaultive act. So here the specific intent is actually proven by how much the child has gone through the grooming narratives with this person. And then constructive intent is actually sometimes in terms of negligence, when unintentional acts can result in the child going into further risk of getting abused. So we have defined the aggravated offense clearly in POCSO. So in simple way of summarization is any person who is in the position of power or authority to protect the child or lives in a domestic relationship with a shared household, as we defined earlier, if they commit the crimes in all these levels, will be put under aggravated offense. As you can see the names here, armed forces, police, doctors, or if it causes grievous injury, or if it causes permanent implications to the child, physical or mental levels, making the child incapable in terms of certain physical anomalies later on, HIV infections, pregnancy, or if you take advantage of a child who's actually not having any kind of power dynamics with you, child who's less than 12, a child who's also mentally or physically disabled, or if the acts committed many times. And even a 2019 amendment added a couple of more elements to the aggravated offense here, as you can see in number 17. If these offenses happen during natural calamity / sectarian violence / any kind of communal situations, war situations, even COVID lockdown situations in institutions, all these are very important to note as again becomes aggravated. And also one more thing was added, which is number 20, which is if the child is persuaded to take any drug or hormone with the intent of early achievement of sexual maturity, very often seen in child trafficking scenarios. Again, all these amount to aggravated. So knowing when the offense is not just a simple offense, but an aggravated offense defines the level of punishment actually. So as you can see clearly, a penetrative sexual assault, clearly 10 years imprisonment can go up to life imprisonment, but it becomes aggravated, or if it is done in less than 16 years, it becomes minimum of 20 years and can definitely be extended to life or death penalty. And sexual assault, again, 3 to 5 years, but when it is aggravated, it goes to 5 to 7 years. Sexual harassment, 3 years or fine. Pornography has a large variety. Storing pornographic materials of child content sometimes can just be fine. You can go up to implicating a child in pornographic material production, can go up to even 3 to 7 years. And this is where the section 19 comes, the failure of reporting. If as professionals, we are failing to report the child, we actually have a potential penalty of 6 months imprisonment, which is where it's very relevant for us to act with accordance to law and also with a lot of smartness. So now let's start wearing our hats. As I described, the first hat, which we are all familiar, is the hat of the clinician. So let us understand what the child has to go through to come to you in that scenario where the child sexual abuse gets disclosed. So disclosure on the first level is not a single event. Disclosure, it's a process. There is a lot of things that the child has to go through. The barriers of socioeconomic status, person and environment interplay, everything playing a role in determining when and how and what level the disclosure happens. So you need to open your eyes and see what are all the barriers and facilitators. Some of the common factors known by theory is the age and gender. Clearly, boys have the least level of disclosure. They've always gone under the radar, which is very sad to say. And kids less than 7 years, obviously because of their cognitive incapacities, have poor level of disclosure. And there are obviously more barriers than disclosure. So you can categorize the disclosure, the rarest one being the first category, which is the purposeful disclosure. The child or the teenager comes out and then tells and reports that. That does not happen very easily. It's often the indirect disclosure where you get to know this has probably happened because of some other outcomes of this particular child sexual event, a mental or a physical assault or a later or a complex or a PTSD presentation. And then you can also have indirect detection through eyewitness or even accidental detection when you go through some other records where you find this thing has happened with this child. So often what we see is, again, with respect to the level of age, the mean age of purposeful disclosure is often higher. So which means younger the child, very less likely to have purposeful disclosure. And often chronic or repeated abuse can be associated with quite quicker and a shorter latency of reporting rather than single events. It's the single events which do have extremely profound impact on the psychological level, but they do not get easily reported. So this is often sometimes we need to remember when we are actually taking place as a clinician. And a kid has to go through all these phases before they go ahead and disclose it to you. First, it's a self phase. They have to understand their victimization internally. And only when they know and have identified that they are the victim here, then they again go into the next phase where they know that they have to report. Then they have to select to whom that they are going to report. This is where the confidant selection phase comes. And this is where all the power dynamics, all the determinants in the environment, who the child knows will give a positive response, all this comes to the child's thinking. And then finally, the consequence creates. If the child goes on and discloses it to a person, there's a lot of consequences, how they react, or how it changes the dynamics of this person. Suddenly, when they know that this is a child who's now reporting to them of all these things that has happened to this child, a lot of things from within the family to a community level happens. And this is where there is a lot of telling difficulties that this particular child or teenager goes through as this disclosure is taking over. And remember, disclosure is again a repeated process. Right? The whole process of disclosure itself is very long term, and every single time when they come to you, come to authorities, come to magistrate, this whole process has to be gone through by the child. That's how difficult this is. Right? And there are barriers which you can clearly understand. Firstly is the developmental immaturity. When the child feels unsafe to disclose, these are barriers within. And then outer barriers are very clearly when there is a lack of poor social. There is actually lack of social support here. There's fear of labeling or taboo, and there are clear power dynamics. There are certain situations where a chronic abuse taking place, and all these children are kept under a kind of a manipulative or a pressured situation where revealing would show some kind of a consequences to them or the family. Most of the perpetrators use these power dynamics, which again acts as one of the first external barriers. Some barriers are there unique for boys here. One of the first thing is actually the socio-political concept of masculine identity being threatened when this boy is able to reveal to someone that he has been abused. There's a lot of mistrust of others, how they will mock him, labeling him as being homosexual, and even change of power dynamics as soon as this little boy is able to come out and disclose. So that's why there is a lot of questions, even in terms of personally questioning one's own gender after being sodomized. All these are important barriers in the context of boys, which we need to be aware of. So what are the few facilitators? Although there are a few certain clear facilitators are there. The first and the most important facilitators I want everyone to remember is you as a clinician asking the child for any possible abuse. The children will never mention unless until they are not asked. And this has to be normalized as a part of any kind of history. When and where, with right level of confidentiality and consent from parents, you can actually ask these questions in front of them to the child. And this has to be the only way where there is actually, you remove all the barriers in that safe room of a clinic, you actually get to know if this has happened to the child. And you need to have high degree of suspicion also to know all scenarios. We'll just quickly discuss that in the next slide. And a lot of the environment where the trusted individuals in the child become essential moderators or assistants for this child to disclose. So you need to know what level of systems are there, including the external systems. If places like authorities, schools, all these people have to have certain level of understanding of what level these children feel in terms of boundaries to come out on their own to others or their peers, right? So what do we do as doctors when we do come out and then feel these circumstances in our practice? So there are certain contexts where CSA comes to you, right? The most simple situation is when the CSA is established already. This is already a case which has been reported and registered under POCSO, established by agencies. The family and parents have already been aware, and then they come to you for mental health intervention. Right. So here already you have a POCSO, FIR, everything filed. If they come from DCPU, District Child Protection Units, document the letter. If they come from NGOs and agencies who are then working with other juvenile police units, again, verify their authenticity of that NGO and then document the referral letter. And then if sometimes it's a clear order from police, then document the FIR copy there also. And this is where the second context where we often get into some kind of a confusion. The child has reported to the parents, right? The parents have no idea. The parents now come to you, right? This can often happen when there is a later disclosure, which we will see later on, right? The abuse has happened long back and now this person is getting disclosed and they've come for intervention. Now, as you're going to give the intervention, you need to take a call how this disclosure has happened. And then a lot of times this also happens. We know something is wrong with this child, some unexplained symptom, which probably will be best explained by trauma, but you don't know what this trauma is. And then you explore, and then you will eventually even probably do even a lorazepam assisted interview, and you will find out these things have happened to this child. Like during exploration, when you do find it, that again brings you to that responsibility of going into the other hats of being the whistleblower or the child advocate and even the witness if necessary. When they do come to you in the other context where obstetricians tend to find, especially in the context commonly in the teenage pregnancy, they are well trained and they are going to give the POCSO referral and they will be calling you only for the psychiatric assessment. Here also most of the job is done. And then when a pediatrician again has some degree of suspicion because of repeated genital infection, they refer to you, then you explore for this and you might again find, and other levels. So this is the level of index of suspicion that I think Sambad's documents clearly explain, I think, for all of us to be aware of. There is an increase in the pyramid in terms of the hierarchy. So disclosure by the child, the self-disclosure has the highest index of suspicion. When the child themselves come out, as you can see, amount of barriers that the child has to cross before telling itself is a big deal. So when the child themselves come and tell you this has happened, it is the highest level of suspicion. But then other things like pregnancy, you can see sexualized behaviors in certain children when they play with a lot of toys and typical oral mouthing manipulations, which are very unusual, and then you can have a suspicion there. Unexplained school avoidance, change of moods, and then these bedwetting, nocturnal neurosis scenarios, all these have to have a level of suspicion where you need to ask and explore. And if you do find, then you need to take the other roles also. The first level response is very simple. You are here to take care of the child. You have to first alleviate the suffering here. Before you go into all the nitty-gritty details of what you have to do as a POCSO compliant clinician, you first have to take care of the child's vulnerability in terms of its anxiety, its safety, provide rest and recreation, teach the child relaxation, create a predictable environment and developmental routines, which are also developmentally suitable for the child. And I hope most of you here will be doing this, right? And then this is the roles that we're all very familiar with. We take the history, we establish rapport, we do all the MSc and medical evaluations. A lot of the detailed medical evaluation in terms of the physical thing also does not come to the burden of the psychiatrist. They go through the pediatricians or the medical officers here, and then they come to you. So most of that burden is also very less on most of us. So what we ideally have to do is first ensure that the child's autonomic nervous systems are settled. And similarly, the autonomic nervous system of the parents and the caregivers are also settled. So here you need to tell them what the child is going through, explain the mental status of the child to them. Then you tell them you need to engage first in developmentally appropriate activities to stabilize the child. Then you tell them why this suspicion is there from your side based on the symptoms and based on the patterns that we have discussed so far. You have to help them understand the child's experience. A lot of these children, in fact, after the abuses happened, several years or several months even pass, their behavior changes clearly. The parents are able to notice that. They become quite defiant at times. A lot of externalizing behavior comes. And all these things have to be explained from this context of this CSA being suspected or even established for the parents to understand. So only then you can actually put the parents in the position of a responsibility to take a lot of important decisions that they're going to be taking as you're going to put them through mandatory reporting and also further legal proceedings. So initial account of abuse is relevant here. So there will be a domain which we will touch on, which is called as the formal abuse inquiry, which should not happen in the first level response. The first level response is, as I said, the main goal is to stabilize the child. But here you still have to take a basic, superficial, initial account of what this abuse incident is. And here you need to use the word alleged in all the documentation. If you looked at all the types of offenses in POCSO, kind of touching or penetration or any kind of offense, you need to use the word alleged perception of or alleged complaint of. That is how because here you've not done a formal inquiry after all the prerequisites. So you use this word in this initial abuse incident that you document here. And then you get a basic detail on what has happened, where it has happened, just to establish a decent timeline so as you are preparing yourself to manage this child on the long-term basis, right? In all the situation, it's also important to know in the initial account to know if the child is actively in a safe situation or not. We will see in certain situations as we go through in the mandatory reporting, sometimes you cannot delay them if the child is still in immediate or imminent danger. If the child is at rescue, then you have to take every step to ensure the child is out of that situation or environment to ensure safety. Right? Now let's go become the whistleblower. What are the mandatory reporting challenges? So there is this unfortunate scenario, right? On one side, if you feel the child itself will have to go through the entire ordeal of legal processes, which itself is very re-traumatizing, right? A person who's already going through PTSD, that too being a child, having to be questioned by these people of these scary authority figures. So a lot of times you then think, well, should I not mention anything and then leave this child alone? The parents are also putting pressure on you. On the other side, then your super ego says, no. This is important for the country. This is a law that is there to protect everyone. You have to, irrespective of whatever this child, this is for the greater good of the humanity, and you report. And this unfortunate scenario is what is called as the Hobson's choice. On either way, you're creating a problem for the child, isn't it? So what you need to do is, thankfully, with Samvad's help, we have a lot of a very clear third level response where you take a middle path here. Instead of damaging the child, you actually go through a process trying to balance either of this. On one side, you're trying to balance the standard norms of child protection, standard norms of consent, child's participation in decision making is ensured, and you understand all the disclosure barriers that this child is going. And on this side, you're following all your legal implications, your mandatory reporting, all your judiciary demands that are mandated, and you're also following your ethical practice. And for this, there is an 8-step guidance that is given, thankfully, by this team from Samvad. So you go through these 8 steps where you're actually involving the child in this decision so that the child's re-traumatization during this process of reporting is reduced as much as possible. So the step 1 is already discussed. Step 1 is you stabilize the child. You focus on the child's mental disorder. Let's say the child has dissociative amnesia of the incident. What can you do? You're not going to get any child victim account from this child, right? You actually have to focus on the mental health. So focus on the healing part, therapeutic process. This can be very variable in terms of timeline. It can be as short as a few days to as long as years together. But then you have to keep that in mind and then go on slowly, knowing when the child is feeling safer and a little bit more in a communicating zone. Educate the children on what has happened to it. Tell this child that this is something which has happened to you, which is quite unfair. This is abuse. And this is where you've been manipulated. A lot of times, most of these children who have been groomed for a long time believe what has happened to them is justified. It's very commonly for you to encounter these scenarios. So you need to educate the child what has happened to the child in the first place. And then tell the child the rights of the child, information about law. What is there as law, which is there to protect your rights, protect your own bodies in this way. If someone goes through a process where they have manipulated you or crossed these boundaries with you, you actually have laws which will punish them. You have to make the child be aware of all these things. And then once you tell them, the child is slowly going to think, okay, now that means I have to fight for my own rights, and which means I'll have to get this person into some punishment, okay, which means I'll be involving with a lot of police. So you then have to elicit all the fears and worries about reporting. You have to sit through the child, maybe even several sessions, to find out what are all the questions and concerns this child has in terms of this whole process, which will happen when the child discloses to everyone, or especially the law authorities. And then slowly go through this process of negotiation, persuasion. You tell the pros and cons. You prepare the child for the cons and motivate the child for the pros. A lot of times it is easier when you have teenagers who actually want to fight for their rights, right? Here, the only con would be the environment, right? But then when you have little children who are quite afraid of police and courts, you have to go through this gentle process of negotiation. And then you list out what will actually happen to them. Who are all these people who will come to you in that process of legal processes that will happen over a period of time, how they will come and address you, what are all the questions they'll be asking you, and how you need to be assured that your safety will be there. And then you also ensure the child's confidentiality. A lot of these things put this fear of child knowing if others will start judging them, and which we see in real life. As soon as a person is given a little bit of a label, even at school, a lot of ostracization happens to these children. So you can imagine how much the confidentiality has to be explained. And thankfully, POCSO addresses those confidentiality concerns. A lot of times you will have files without the names of the victims as well, right? It will be known as unknown admitted on that. That's how file names are there for POCSO cases in POCSO wards in many of the institutions. And none of the media ideally should be, as per the law, are even allowed to interview or take any information. Even indirect information about the area of this so-and-so thing happening, if it actually gets the people to guess who this person is, will also be punishable under POCSO. Right? And finally, when you go through all these steps, you then take a consent or an unsent without any coercion. If there is a lot of hiccups in this process, again, go back to step 2 or 6. So once that is ready, how do you report? So what POCSO says is ideally report to juvenile police unit, right? So then we don't know where to find them. We obviously struggle in which jurisdiction they come under, which police will be immediately able to handle. And as soon as you say you go and report to police, the family members are no, absolutely not. They're having lots of trouble. So if you're lucky, if your institution has a protocol, if your resident medical officers are trained in this, it's an easy job. You prepare the report of this child, you hand it over to them, and they will take care of reporting. But then if in other situations where you're a private practitioner or in a private institution, thankfully, you have a wonderful 1098 child helpline that is present all throughout our country 24/7, which will connect you through the DCPU, which is District Child Protection Officers, and the Child Welfare Committee, right? Many states actually have CWC websites where you can have email. And as soon as you call them, a couple of things are necessary for you to have in terms of your data for them to know when you're reporting it. So firstly, you actually have the Aadhaar card of the family and the child, ideally, to know the domicile from which they're belonging. So the first thing they will ask is which jurisdiction or which area do they belong from. Then you need to provide a working contact number of the family member while reporting to them. They will take it through the phone as you're mentioning them, and then they will call them also, and they will cross-check what you've said, right? And then after this is done, mostly you can actually send a formal email to the CWC. Most of the districts and states have this. In Tamil Nadu, 1098 itself is directly going to connect you to clear-cut service CWC help committee that will contact back. But in many states, you have district level email addresses of each person, and you can email them and then save it as a copy that you have done the reporting. Now, then we'll go to the sticky situation where you're not able to get that across. All those 7 steps are taking a lot of time for you to get that clear-cut consent from the child, and the family members are also not able to come to a decision. What do you do? Never ever document that the parents or the child is refusing to get reported. That cannot be allowed because it's mandatory reporting. What you can do is continue to document your attempts to report as you go through the process. Write down the data in terms of all the sessions that you've conducted to educate them about the mandatory reporting clause. You can even get a signature that this has been told to them and they've understood that this clause is there for the doctor to act accordingly. So that is what they are trying to do. You can even get a consent for that information as well. Never ever document that they have refused and hence you have not yet reported. That will actually work against you. And there are certain situations if this process is getting dragged, takes a lot of time. But then if you know this child is at high risk, like high risk situation is when the abuse is still happening, a family member being a perpetrator, not very rare as well. And if the child and everyone is afraid of reporting because of there is some power dynamics in that village or that place, but then there is still that risk of this child getting again and again abused. In all these situations, you go ahead and report. How do you do that? You talk to, if it's a family member who's a perpetrator, talk to the non-abusive members. Try to take the child's living conditions separate from that abuser, or there is always a shelter home, or child protection authorities will take the child to a more safer place, which is easily done when you report, to ensure that the child's safety is assured, right? Sometimes prioritize physical safety even over mental consequences. Let's say even a PTSD child who's having a lot of dissociative seizures in front of you, if the abuser is probably still there back in the village, and if you go back, then they have heard that this person is trying to complain police and they're going to give you some kind of a physical threat. Again, it is important that you try to go against the family or child's wishes in order to again protect and also to do your rightful duty here. So sometimes you have to override the family's decision in those situations and proceed with mandatory reporting. So these were all clear-cut scenarios, right? Now we'll go to certain scenarios where it's not very clear, which is very gray. This is a Danish movie. The poster you're seeing here, it's called The Hunt. It's a wonderful movie about a person who gets implicated because of false reporting of child sexual abuse. The child reports something about seeing some long, slender shaped object, and then the teachers suddenly feel alarmed that maybe this is some kind of a penis. And then they repeatedly ask this child, false memory is created, and the person who's actually a very decent person gets implicated. So there is a lot of gray areas in POCSO that we need to remember, right? Firstly, we try to be whistleblowers, right? Yeah, whistleblowers will be anonymous. That's the good news, right? It will be confidential. The bad news is they do not protect you as a whistleblower, or even the witness themselves do not have a clear-cut protection unless until your lawyer fights for it, right? And then the most common gray area is your adolescent consent abuse binary. You have a 16-year-old and a 17-year-old who are in love, and then they have sexual intercourse. And then what's the problem there? Well, there is a big problem there because both of them can be implicated under POCSO here. And often this is a little bit in terms of our cultural allocations tilted towards the problem of victimization is obviously tilted towards the female because of the power dynamics in play. And here also we will discuss in detail what are the things that we need to remember. And obviously the problems of false allegations, false memory, we need to be careful. How do we be careful? I'll discuss that as we go into the formal abuse inquiry stages. And sometimes when the parents refuse, but the child is clearly willing. These are scenarios you will encounter, especially in teenage, when they are late reporting to you after several years. My uncle did this to me, and the mother or the father wants to protect their brother, or and they refuse. And what do you do? Again, you have to be the child's advocate here and clearly try to put the best interest of the child or the teenager here. The time frame creates a lot of problem. We'll discuss a little bit about the time frame going on, and also we'll touch on the child marriage issues here one by one. So yeah, clinical reality is very nuanced. POCSO is sometimes very blunt in many of these ways. As you can see from the first statement I told you, 1 day less than 18-year-old, you'll still be treated as a child as per this law. So that puts a lot of institutions in perspective. The most common legal dilemma being the mutually consenting relationships between 16 to 17 years old. Thankfully, many of the courts, a lot of landmark judgments from Madras High Courts have come out, which has ensured to destigmatize this and try to reduce any kind of legal implication that is put on these teenagers, right? But unfortunately, if the power dynamics are different in terms of age gap being 5 years or more, the older person, even if they're minor, if they're even 5 years or older, there brings the possibility of a manipulated consent of the victim here. And those situation, it will be statutory rape, or it will be actually seen in a very serious lens of POCSO. Right? And here is where you need to be, as a psychiatrist, often you get called to assess what is the mental age of this child, what is the level of credibility of the consent given by this teenager to this other teenager. Was there any manipulation taken place? A lot of your psychological IQ assessments are necessary here. But often it's a clear POCSO case if one partner is just above 18 and the other is just above, less than 18. One is 18 years, 2 months, one is 17 years, 10 months. It's a clear-cut POCSO case. I'm sure you cannot do anything here because 18 is a dichotomous cutoff. So there, whatever you do, the law also will not be able to save that person unless until the other, the legal proceedings, which will go later over time, will try to defend the accused. Now we talk about the CSA reported after a lot of time. Now this is very important in POCSO. POCSO does not talk about any time limit for reporting. No, absolutely not. As long as this person's offense has happened after the enactment of POCSO. So for example, POCSO does not mind, let's say if the victim is less than 18, she is around 17, and she talks about an incident that has happened when she was like 12 years old. Here also mandatory reporting of POCSO is still in place. Here also all the proceedings have to be done under POCSO. And often here also the burden of disapproval still falls on the accused, right? And if that victim is held up at special court, a lot of times your collateral evidences of the impact of the CSA on this particular victim, let's say if there is a personality change that has happened because of it, a chronic course of PTSD that has happened after it, all these things will be helpful from your psychiatric assessments to corroborate the account, which will actually ensure that the time that has passed has also been impacted by the CSA that has happened long back. So those contexts come to you as a clinician then. And then sometimes when there are adults who are now clearly above 18 and who then recall that they have a CSA experience that has happened long back, right? Now they want to file and they want to fight for it. And this is also very common. Here also, yes, as per POCSO, the mandatory clause allows you to definitely say it. But what also can help here is because them being adults themselves, they can also then on their own accord go and file a case as well. So here it is actually a little less easier. You can just see through what are the legal rights that this person is aware of. You can tell them within their rights what they can be and able to fight for, right? Sometimes LGBTQ and boys are overlooked. As I keep repeating this, POCSO is clearly gender neutral. So a lot of times boys with a lot of disclosure problems come out, and then here it should not be dismissed as that they cannot be sexually abused. So here also POCSO clearly applies. And a lot of times transgender youth, we've had a couple of cases during my time in PGI where a clear-cut transgender person who's already gone through a lot of minority distress then also mentions how they have had CSA. So we are still bound by the law to help them get mandatorily reported and help them survive the legal process through psychiatric support here. So you must explicitly document and validate abuse regardless of the child's gender and gender identity. And then comes the familiar issue of child marriage, which is much more severe across the places where I've been in, especially in Ranchi and Bihar, and also pretty common in many other parts of the country also. What child marriage says is very interesting. Child marriages are not void but voidable, which means marriage can happen unless until someone tries to protest it. But it clearly tells the sexual intercourse in the child marriage is clearly amounting to rape. There is no confusion about that. But then the marriage per se can be voidable, but not just like that void. So what can happen? Either if the person who's a child person who's now married, less than the age of 18, their family members who feel they want to, cancel the marriage can file the petition to the child marriage prohibition officer. Or if that person is above 18, they can themselves file the petition, but then they have a time of 2 years for them to annul this. If it is crossed to 2 years, then they cannot file that also under Prohibition of Child Marriages Act. But then unambiguously, if that marriage involves sexual intercourse, this is a minor who's in child marriage, who's now undergone sexual intercourse, it is clearly defined as aggravated sexual assault. And it can clearly amount to POCSO level offenses. And here mandatory reporting is still applicable. So this is pretty clear and straightforward. So what do you do when you become the witness? Right now, this is going to be a little bit of a lengthy session. I'll try to go through it in subtle details. So you are responsible for developmental assessment. The most common position where you are as a psychiatrist, both when you're functioning as a DMHP level, medical officer level, even when you're working in private clinics, is a couple of important assessments is what was the level of developmental achievement for this child during the time of this offense being committed. And often after the level of abuse that has happened, some children can go even into pseudo regression, where this assessment itself becomes very difficult. So all these things have to be clearly documented through your assessment and your evaluation. So only to know how much stabilization is needed for this child, for later on this child to go into any kind of legal proceedings, right? So clear-cut developmental assessment has to precede any kind of formal forensic interviewing or even statement retrieval by legal professionals. You need to look into the narrative ability. Narrative ability is limited by certain situations like intellectual disability, age less than 3.5, obvious speech delays, or clear-cut trauma or PTSD causing some impairments or regression. Here, it is only the parent or the mental health professional whose statement will be recorded in these situations. You cannot rely on the narrative ability of the child, right? And before you go on to do any formal abuse inquiry, ensure you establish the credibility of this child's victim report. Right? How do you do that? You need to go through a couple of things as you do your assessments here. First, during your play assessments, in a very child-oriented way of techniques that you follow, see if this child is having the capacity to differentiate what is true and what is false. If the child is able to, as you talk, is able to say as if that the child is understood or not understood something that you have said. The child has to make this explicit statement to you as you're interacting, when the child is able to clearly tell, no, I'm not able to understand it. So that you need to know if this child is able to tell that to you. That is very important. And then the child is also able to point out when you are making a false statement. Why are we doing all this? Because a lot of the legal proceedings will involve people putting a lot of unnecessary things into the heads of the child. We just saw what can happen with false memories, right? So you need to establish credibly the child is able to differentiate these things. You also have to know if the child is quite having a capable episodic memory which can be recalled reliably. How do you test that? Simple cognitive tests during your play therapy assessments, where you can see if the child is able to label objects, identify spaces, describe actions and narratives of the behavior that the child is seeing. Can the child say the sequence of events? This is first, this is second, this is third. See overall descriptive abilities, identify body parts clearly. So the overall receptive language, recall of the episodic memory, you have to assess and give in your reports to know again. These reports will then serve as a clear-cut credibility of this child's narrative. With all that developmental and the credible reporting capacity established, only then you go to a formal abuse inquiry. Often, if we are in private institutions and private practice, we do not have to do this. But quite often, if you're in government institutions or if you're in active government-aided child psychiatric clinics, you will definitely be called in to do this abuse inquiry. And here you need to know what are all the technical things that are necessary to do this in a very, very non-suggestive way. One of the ways the defending side will always try to discredit you is if you have suggested these things to the child, right? So you need to again do this in a very clear-cut way. If possible, video recorded. If you're quite an experienced person with a lot of clear-cut protocol established in your routine, you can actually go ahead and record this. So that will give a clear-cut proof that you're showing the abuse inquiry, which is done in a proper way. Otherwise, try to do certain following methods here. As generally we do in psychiatry, always use open-ended questions. Use this always the statement of tell me what happened, right? You can slightly tell some hints towards it. If the young child, you can say, I can see you have some small problem. No, I know someone was there. Some uncle was police was then talking to you. What has happened? Why are you here? So always start with an open-ended question. And then as you go on to collect the details, always match it with the initial abuse account that you've gotten, and then go into certain spectrum of leading questions from minimal leading initially to moderate and then maximal leading. So the obvious leading questions in terms of yes or no questions should come very end of this inquiry. And only to confirm certain facts, you can use close-ended questions and finish the interview. Thank the child's cooperation. And again, this whole abuse inquiry is not a single event sometimes. It can take a lot of events as well. We'll see what are the attention span that you'll go through with this child. The engagement time is very important here. And there again is a developmental implication here. Younger the child, less their attention span. So if you're talking about a very small child, already the narrative ability is impaired. Their duration of engagement is also impaired. So you cannot sit through a long abuse inquiry. But then it gets better and better as you go towards teenage. 10 to 12-year-olds can even sit up to 1 hour for formal abuse inquiry. Always avoid compound questions. Don't ask two questions combined into one. Where were you and what were you doing? Don't ask embedded questions. Do you remember what you were doing? Remember and also what you were doing. So that those things again are going to be very confusing for the child. Avoid ambiguous questions. Avoid questions which are very abstract. Be very simple, very clear cut, but very open. Fact based. Okay. And a lot of times context has to be given to the child when you're asking certain questions. You can take any kind of autobiographical landmarks around your birthday, around Diwali, around Pongal. So those things, again, as usual, we do in adult interview also will be helpful for children also. So this is a simple picture that helps you to understand the depth of information that can come through age. Younger the child, very basic data only is available. Who and what. Maybe the child will be asked to point. That's it. The picture to be identified. That's it. But then as the child is growing into ages of 8, 10, and 12, the structured reporting becomes more and more possible, including the contextual details in teenagers, that you can actually set the other things such as the specific intent, beyond the general intent, the grooming narratives, all these things become clear in terms of setting the contact in your report. And finally, there will be situations where we'll have to go to court, right? Firstly, the child has to go to court. So you can actually tell the child as you are preparing the child during this process, tell what will happen. This is also done sometimes as you're getting the mandatory reporting preparation for the child. You tell what will usually happen. You can tell who are all the people who will be involved. POCSO definitely does a good job here, ensures that largely females are involved. No person wears any uniform. They can interview and take the statement of the child at home in their comfort zones, in the friendly, non-threatening environment. All these things can be told to the child, and absolutely no kind of intimidation is allowed. Although this is something which is not very practically seen, at least from my experience, they often do end up intimidating the kids, but then that's simply because the system is not yet trained to that level. But then this is something which at least you can tell the child and prepare them that you can meet these kind of people here, so be ready to answer to them. And now when you yourselves are now called as an expert witness, when do they actually call you, right? They call you to provide a set of conclusion about a relevant fact and about the fact and issue. And then what you give is an opinion, and it will only remain an opinion. And this is the thought clarity that we all have to carry when we go as expert witness. So when you give based on your experience and your credible knowledge, what you have told again remains an opinion. The court or the jury has to adopt the reasoning of what you've told and then tell this as their opinion. So the expert opinion technically becomes the opinion of the court only, and it will only assist in the final decision that the judge will take. So that is the simplest way to relieve yourself of all the burden that you're carrying. You're here to provide an opinion. So that eases all the tension, especially when you're going as a first time. Expert evidence are only to testify about facts that is within their exclusive knowledge. Neither you will be asked any question outside your knowledge. If at all you are asked, you're allowed to tell that is not your expertise, and you better tell that it is not your expertise. But then you are here to answer certain questions, opinion on the causal relationship between the act and the consequence. One of my friends during my DM times had to go, and she had this scenario where this was a case, had OCD following CS, right? Can happen. And then the defendants were trying to discredit that OCD can be genetic and not because of CSA. So all these challenges will happen when you're in an expert witness. You have to be taken on your expertise to opinion on what kind of relationship exists between the act of CSA and the current impact, the consequence, or the whatever the victim is going through. So mostly expert evidence is very important in establishing one, inferences, and two, causality. And it has to be taken from all the circumstantial evidences that are surrounding the case, and it will add one more weightage to the evidence. And as you share, your expert credibility is also very clearly tested. So there will be two levels of questioning. Firstly, by the prosecutor or the examination, and the cross examination by the defense counsel happens. And both of them will first establish your credibility. The examination chief will establish your credibility, and the cross examiner will try to discredit your expertise. So you need to have a clear-cut SOB in how you approach your cases in your clinic. The clear-cut documentations would always help. Your training and behavior of your staffs in your institutions, and if your institution itself has clear-cut POCSO protocols, also helps in all these questions. So what they will do is they will try to establish credibility of expert, and then slowly take your practice-informed inferences and opinions regarding causality. That's all is your job. So I think with that, I will now conclude to the final take-home points. I hope I've taken you through all the four hats. So you need to remember, POCSO always has a presumption of intent. The burden of disproving falls on the perpetrator. Your priority first is to wear the hat of the clinician, safety first, right? And then you also have to take the hat of a whistleblower, navigate through all the dilemmas safely to ensure the child's wishes and mental state is protected. Then you become the advocate in all the gray zones that we saw in terms of child marriages, in LGBTQ issues, where the best interest of the child and teenager has to be protected. And establish the episodic and protect the episodic memory without any suggestions, because it is easily suggestible. Validate the witness competency by your own assessments of the developmental level, the capacity for the child to differentiate things. And then you also implement certain sport preparation. And also the sport preparation has to be done very tactfully, so as to not be accused yourself as being suggesting the child. And finally, fortify your expert credibility. So with that, I will conclude this topic, and hopefully we can take some questions. I think this was a little information heavy, and I've gone through very fast, but I think within the limitations of the time, I hope we can answer some more questions.
Thank you, Dr. Vel, for the very informative session. Dr. Vel, would you like to take up some questions on the chat box, which is already there?
Yeah. Just opening them. So one of the questions is what to do when a child who is already having severe mental distress due to the other reasons. Yeah. So the first protocol is you be the clinician first, stabilize the child. Unless until the child is stabilized, any kind of processes which will cause re-traumatization of the child has to be avoided. But then one exception is when the child is already in a situation where active abuse is taking place, then you will have to take a stand of reporting the child and removing the child from that situation. Otherwise, you treat the child first. Parents are not willing for legal reporting and not bringing the child for follow-ups to go through the steps described, what we can do. Yeah, every time you get an opportunity where in your presence this CSA disclosure has happened, you better document it then and there. Right? That opportunity is definitely there for you to say that in that instance, I had an opportunity that this reporting has to be done, and you can at least document that you made an effort to tell them that reporting is mandatory. And then I've called them for follow-up. Then if they do not come back for follow-up, then at least the burden on you falls down, because you've at least made an attempt, and then ensure that they come back for follow-up, right? A person's chronological age is more than 18, but mental age is less than. Yeah. So technicality here is the developmental age, again, will be implicated from your side to understand the impact of the trauma this child has taken place. But if the actual incidence of CSA, if it happened beyond the age of 18, based on their chronological age, this is unfortunately the legal aspects are very blurred here. The defendants can clearly say this is not where POCSO will be applied, because this person is no more a child. And although you can still provide a report in these scenarios that developmentally this child was vulnerable, the power dynamics still play. And you hope that you could create enough document to help this person who's a victim here. Is there any other question? Yeah. Currently around 30 years and reports of CSA in the past, but they don't want to report. What will be our role here? Very interesting. Uh, Firstly, if the incidence has happened before 2012, when POCSO law did not come into enforcement, a law becomes enforced and valid in the country only from the time of its enforcement. So if that abuse has happened before POCSO came into force, there is absolutely no mandatory clause for you to report. But if it has happened after, here you can clearly tell them that you are an adult and you have enough reason for you to go ahead and then report here. But this is a very tricky area. POCSO does not mention that if you are an adult and then you clearly are independently able to report, you are then relieved of your responsibility. POCSO does not tell that. So a lot of times in ground level, what usually happens is we actually push the person to go ahead, just document that there is alleged history. You try to push the person to go ahead and make that effort of reporting themselves and try to take action legally from their side, which they are definitely entitled to do if the offense has happened after 2012. But then a lot of time this is decided by what level of provision in terms of your position of government position or your private position mandates, the pragmatic difficulties that come through here. So this is again one of the gray areas where, but what you try to tell them is you tell them that these are the rights that they clearly have, and you try to push them that if they can go ahead and then fight for that. Situation where there is chance of tutoring and false reporting by the child. Yeah, that is a very risky situation. You have to understand that if the child comes to you in which level. If the child has come to you in level where CSA is already established, whatever way be it, if it is through false reporting or not, if POCSO is already there established, your job becomes very limited here. You're here to at least settle the mental health issues that comes from this dysfunctional family. But if then there is a situation where the reporting has not yet happened and you're able to see some foul play is in position, you have to be very clear in your documentation as what this child already has been going through in the family, what are the actual collateral evidences that is there, and clearly use certain alleged history or so and so has been reported by the child, and then also bring into other context that you see in the family in terms of family discord that is there. Then you still have to report it here, because now this, if it's coming from the child and you are bound to report it, but then you leave it for the law and order to take its course there. Here, your job as a clinician and also the person who is a child advocate is to still work with the best interest of the child here. If you are there bound to protect the child using the law, you have to do it there. I hope that answers the question. I think, yeah, we're going to get a lot of questions here. Adolescent girl less than 18 years, presents with PTSD. Reveals past history of abuse, not willing to report assets in the past and done by another minor. Not a problem, no, and wanting only treatment. Yeah, so again, this is the adolescent consent abuse binary, right? If here, the first thing you do is first you understand if both the persons are minors at the time of this getting committed. And then if the age gap hopefully is not more than 5 years. If there is a kind of a power dynamics and play, it becomes a very tricky situation because both are minors. So this is a clear-cut gray area where not much can be done, because the incidence involves two minors here. Unless until the person themselves are, who's the family member here, want to come and make an issue out of this, where you again have to educate them what POCSO tells here. Both are here under 18, and POCSO cannot be clearly applied in these situations. Right? And if they are ready to forget that and move on and try to get their own mental health taken care of in a future-oriented manner, then you proceed with only helping them as a psychiatrist. Abused by another minor during play activity. This is clearly the gray area. If it is without consent, it has happened, power dynamics are in play. But if it is done by a minor, then it is very limited in POCSO. But you can still see if this person is maybe nearly the age of 18 and above, just nearly crossing 18. A lot of times the age is forgotten. So at least you try to see whatever the collateral evidence is given by the family members say that this person may be above 18, then you go ahead and report it. So the CWC authorities will come and verify it for you at least. Your job here is done. So if the index of suspicion is telling you this person may be just above 18, but if they are clearly less than 18, this person was 8th standard and she was 7th standard, although they manipulated and this happened, it's a very unfortunate situation. Not much can be done here. Yeah, again, mandated reporting mean that even family does not want to report. Yeah, there are several situations family will not have to or want to report. And they are very clear about that because they will tell that, no, this is going to create a lot of taboo in my family and society, which they are very rightfully demanding from their personal experience. But here, as we have discussed, right, you have to take a call based on the safety of the child, the impact that this abuse has had on the child, and then clearly proceed with reporting if it is fulfilling all the criteria that we saw today. Situation where mother threatened to commit suicide if we report, as the abuser is the father. Yeah, this is one of the worst situations that you can encounter here. Now, this is a situation we've had one experience where this has happened. We are talking about a scenario where it is the elder brother and the younger sister, and the elder brother is clearly above 18, who's going to college and everything. And there are two younger sisters. The father, like in many cases, is clearly absent, and in Pondicherry situation is also an alcoholic. Now, this brother continued to abuse the child, and the mother was a completely pathetic situation here. She did not want this to get reported because it's both her children here. What do you do in this situation? It's very difficult for us. What we did tell them is that this is definitely a situation where we want you to report. We documented that, and then we hopefully asked the family to take their time in processing this and then come back. And for all practical purposes, they did not come back, but we at least have a documentation that we did this and we've got the signature that this is necessary for you to report. But then you come back when the child is absolutely better, and we'll go ahead with the process, right? And these are situations where even follow becomes difficult. Often these are situations where the family is quite in a very pathetic situation. There is one other experience where it was a family member who lives nearby, and this is a clear-cut case where the child had many vulnerabilities. She had intellectual disability, and the person was there in the same neighborhood. Both the parents were working. They did not have any capacity to fight. So we went against their wish, and then we reported, and the child had to be taken to a shelter home where she was better protected. And then we were able to at least get the follow-ups done through CWC, thankfully, who brought the child every month to ensure that this child is at least doing well. And she was doing better than before. And then the good news was in this case that the perpetrator then died because of some RTA, and then we were able to reunite her back with the family. Those things happened. So this last question here is 28-year-old clinically suspected of intellectual disability, proceeded for assessment. 75% disability issued. Patient is not reporting the incident exactly for 3 instances. Okay. If she's able to give statement or not is the question here. Yeah. So here we need to know the narrative ability of this child is clear. Then this becomes the complicated case, right? You again and again have asked the same questions to a child who's already having moderate level of intellectual disability. So the formal inquiry has become more corrupted to a point where it is very difficult to say. A couple of experiences from certain medical officers, which I've also talked and interacted. One of the things that the defense counsel will clearly ask is, now that you know that she is intellectually disabled, how are you so confident that this child is telling this is true? There's absolutely no answer there. Your opinion then becomes a difficult way for you to justify what has happened, and purely through the basis of the child witness's account, because the account can clearly become discredited here. But you do your duty. You at least bring the situation to the awareness of the court authorities. Take the person to the court at least, because the 10 cases we report, at least maybe 1 or 2 go to the court. And among them, it is very difficult to see who goes through and finally gets the judgment. So at least what we can see is those people who then are taken to court will then become very aware and then stop messing with the person, messing with the child, and even offer some compensations. So a lot of times this goes on to even help the situation where the family is now hell-bent on fighting for the child. They even try to give imminent justice among themselves by calling the entire panchayat and asking the person to apologize, or even get them thrashed within their own justice within the village system. Those things always happen. But your duty is to protect the right, report it wherever necessary. So good things can happen that way also. But then this is a scenario where it's very less likely that the court will have a clear-cut direction.
Dr. Vel, we have the last two questions, and we'll have some comments from senior
Yes.
psychiatrists who are there in the group. Yeah.
Sure, sir. Sure, sir. Yeah. So, situation where a mentally ill patient's family tells that the patient abused a child. Mentally ill patient. Oh, yeah. No, that's a problem. No, child is not in your clinic. Okay. Do we mandate to report the case of a child who you have? No, of course not. We cannot. We cannot. The child is not seen by you. We cannot. We can tell them you bring the child. You at least document that this is again an alleged report of the family member claiming the child to have been molested or assaulted, whatever the terminologies you need to know and be aware, and then suggested for the family to bring the child for detailed inquiry. That's it. Child's father is abusing her. Again, very, very difficult scenario. Father, if the father is the accused here, you have to be really, really, hell-bent on protecting the child in the first place here. So at all costs, you ensure that the mother is often what we call as abuse accommodation syndrome. This happens in most of the families when there is chronic abuse within family. Mother is one of the persons who has accommodated the abuse. You cannot get this mother out of this mindset. You actually have to treat the mother also here. But then your duty upholds that you protect the child. So you try your best. As I said, there are situations where you really have to separate the family if this is still better result for the child. And a lot of time that helps. You have cases where family members, the victim children have had so much of abuse that they become affected over time. They become juveniles. They develop all those conduct issues. Some of them have ended up killing their own parents. All these things are the trajectory of these families. You are at least trying to ensure that it can still get worse, that level of worsening is not happening if you do intervene and report then and there. Yeah, so I think I hopefully answered questions.
Yeah. Sincere thanks to Dr. Vel Prashanth for throwing light on the actual nuances of POCSO. And I think like the take-home message was very, very clear on the intent. So both on the sexual intent for the crime from the perpetrator's side, as well as our intent to ensure that like we are also having an intent to report, even if there is mandatory reporting that does not happen. I think you should ensure that our intent was very clear that like we have coaxed the family members to actually, or we have been guiding the family members to actually report in the process. So thank you so much for that excellent presentation. We have senior psychiatrists like Jayantini ma'am. Thank you so much, ma'am, for joining. And Dr. Anil Kumar sir from Trivandrum sir. Ma'am, if you have some comments and your expertise to share, ma'am, we'll be happy to hear, ma'am.
The one thing is, the last one, the father is the abuser. Mother cannot do anything in that situation. In such situations, the grandparents can be called with the consent from by the mother, and then you tell them about the facts. And if the grandparents are willing to take away this child and look after, it is better for the kid. Of course, the grandparents have to tell the father if he is not going to allow the child to go with them, then they have to report. And we may have to provide the financial support for the child's education also, barring which we are forced to report. In such situations, the parents yield in general because they have to protect their family prestige and to protect the father from the police action, and they are willing to send the children or child with either side grandparents, more so with the maternal side. The paternal side in reality try to support their son in general. Or in some cases, I have asked the Periyamas or Attais or someone whom the mother is able to accept and send the child with them so that she doesn't undergo repeated abuses by the father. In this case, the father was an alcoholic. He was not willing to get treatment. Under the influence of alcohol, he was abusing the daughters. The mother came and told me, either way, she will commit suicide. If he continues to abuse also, she will commit suicide. And if we tell the authorities also, she will commit suicide. It's a very tricky situation, but somewhere we have got to help. Of
Thank
course,
you.
in our setup, in general, family members who are really involved are willing to help.
Thank you so much, ma'am. Sir, Dr. Anil Kumar, sir, thank you so much for joining. So would you like to comment or give your suggestions?
Hi, thank you, Raman sir. And congratulations, Vel Prashanth, for excellent presentation. I could join only towards the latter part of the presentation. And working in government hospital and medical college, and we also face this difficult situation whether to report or not. And we are mandatory is there to report. But most of the cases, we recommend admission in the ward, the child ward, along with mother, and prepare the mother and child and explain the need for reporting to protect the child from further abuse and also to protect other children from abuse by the abuser. If you are keeping it silent, the perpetrator will continue the behavior and it is a damage to the society and it will continue. So we'll buy some time, educate and prepare. And most of the time we'll agree and the child and the mother will agree and in the same time, you will work with the CWC for the safety of the child to shift to a protected environment. If the safety of the environment, the family is not safe for the child. So anyway, it is individualized and we have to work with the multiple agencies and help of social worker, psychologist. So we have to work in a team and find a solution for that. Thank you. Excellent presentation.
Thank you so much, sir. So we have our president, sir, of Tamil Nadu IPS chapter, Dr. Sadanand, sir. So, please kindly share your expertise on this topic.
Yeah, thank you. Prashanth, Vel Prashanth had an excellent presentation. And there are areas where too minor nowadays you have children 10th standard who are having affairs and getting into the sexual life, and managing them is a difficult area. A lot of areas, as he mentioned, there are difficult areas there which we come across. And sometimes the girl's mother wants to complain and create problems for the boy's family. So they said, no, we want. So a lot of these sort of situations also some of our colleagues face. So a lot of gray areas. And I think so we find ways to come across, or maybe some amendments in the act would help us go through it. Anyway, once again, thank you. Excellent presentation, Vel Prashanth.
Yes, sir. Thank you. Thank you so much, sir. And I think we will just come to the end of the session. And if there are any questions or clarifications, I think Dr. Vel has shared his mail ID, I think. So if at all people who are interested actually can just connect and definitely clarify for individual case-based any clarification or queries that we are actually facing. So I'm really, really happy that to hear this CME for today. And you have made it very, very clear on most of the gray areas. I think it is very important that this topic and from the institution side also, as sir was saying, I think most of the institutions should have a policy on this.
Yes.
So I think that is what has to be pushed on an individual level. I think you are accountable, you will have to actually document, mandatory report and everything. But many a times we come across situations where as a psychiatrist, you might be as part of the institution, you want to report, but the institution might have a different policy. So this will be, again, you'll be caught in an ethical dilemma. If you are an individual as a practitioner, then you have to fight only with the family. So, but if you are in an institution where the institution policy is not very clear, then again, you will have to fight with the institution also, as well as you will have to actually clearly convey to the family members also. So this is one area where we all our institutions have to actually come up with some policy regarding reporting and regarding POCSO. So I sincerely thank Dr. Vel Prashanth for taking out your time and making a very lucid presentation today. And I sincerely thank President Sir and all the EC members of Tamil Nadu chapter of IPS for giving this opportunity. And we will look forward to in the next month, the third week, with another interesting topic in child psychiatry webinar series. Thank you all. I thank Dr. Shainika for co-hosting and ensuring that preparation is on time, and she ensures that all the invitation is being sent on time. I sincerely thank her also as part of the series. Thank you. Thank you all, and thank you all the participants who joined.
Thank you, sir.
Thank you.